So welcome everybody, my name is Nigel Sansom, I'm Director of Research here at Faculty of Medical Science, and I just want to give a quick first half-hour session on the introduction to intellectual property. But before we get into that, just a little scene setting about what we do here. Much of what we do in our faculty is translational research, which means different things to different people. For some, it's a bench-to-bedside enterprise of harnessing knowledge from basic science to produce new drugs, devices and treatment options for patients. For others, it's more about translating research into practice, i.e. ensuring that new treatments and research knowledge actually reach the patient or population they're intended to benefit. And the translation gap is something that we need to close, and to do that, we need to recognise that much of what we do here is translational research, that pre-competitive collaboration is important, the importance of networking, business planning, modelling, if we're going to commercialise something, which we'll be talking about more in detail later on, the validation of our target markets, the real important thing about finding out who it is that we're trying to create value, whose pains, needs and gains are we addressing. And of course, the thing that we're going to be talking about mostly here in this first session, intellectual property and intellectual property rights. And to aid closing the translation gap in FMS research, we will ultimately define clinical utility before we've spent millions. Chance would be a fine thing to spend millions here, wouldn't it? Understand who it is we're creating value for, understanding the routes and relationships needed to reach them, the key activities and key resources required. This is really important stuff for business planning. Understand what data will be required before doing the science, the different vehicles we need to finance our ideas. Accept that there are no answers in the building. It's a bit of a buzz term. In the third session, we'll be talking more about what that means. And assess IP and regulatory risk before we've designed and built product. So, cracking on with the subject of the first session, what is IP? The term intellectual property refers to creations of the intellect for which a monopoly is assigned to designated owners by law. And I'm going to go on in a bit to talk about the various types of intellectual property rights. The term goes back for quite a long way. In the 19th century, it became popular in the 20th century and can be traced back to the Statute of Monopolies and the Statute of Anne from 1710. And these firmly established the concept of intellectual property. They are a means by which we protect innovation. So if you can just see this, it says, this is the Statute of Anne, an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the times therein. That's a pretty ancient document, and those are the sort of things that are the basis of our intellectual property as we know and love today. So types of IPRs, types of intellectual property rights. We have a patent, an exclusive right to prevent others from selling, making and using the patented invention for a certain period, usually 20 years in the UK, 20 years in Europe. Copyright protects the expression of literary or artistic work. Protection arises automatically, giving the holder the exclusive right to control, reproduce or adapt. Sui generis is a bit of Latin, so it's a thing in of itself, like database rights are a form of copyright. Trademark, so we've all come across trademarks in the past. A distinctive sign which is used to distinguish the products or services of one business from others, and to infringe a trademark lets you open to litigation from companies who feel that you're passing off as them. Design rights has two forms, registered and unregistered design rights, that protects the form of outward appearance or aesthetic style in an object. And proprietary knowledge, the stuff that you keep to yourself effectively, is a form of intellectual property right. So starting with patent, a patent is generally a government license concerning a right for a set period, especially the sole right to exclude others from making, using or selling an invention. It's cheap to file, so about £2,000, £2,500 in the UK, but can get very expensive downstream, especially in the national phases where it's translated into the various languages. So you may start with a UK patent and then you have that thing translated into German, or downstream you might want it translated into Chinese and Japanese and Malaysian, and that's where it starts to get really pricey. Some say that a patent is only really valuable after it's been successfully defended. So when you go apply for a patent and have it granted and published, and you're out there, making some money off of it, it's possible that somebody else might come along and say, actually, I'm going to do the same thing, and I've got enough money to fight you. Do you want to go to court? And you've got to defend your patent, because they might think that there's holes in it. They might think that it's a weak patent. Some patents are stronger than others. And successfully defending a patent can be very expensive. A patent can be licensed from the university to a spin-out, which may use part of its funding towards the IPR costs, and I'll come on to that later on. Of course, patent or any form of intellectual property right can effectively be licensed to other parties who'll pay for the right to use it. The nice thing about licensing is that others become liable for those IPR costs. So when I mentioned about the national phases being really expensive, you can offload that to somebody else and do a deal. Can I get a patent from my invention, a guide for inventors? Basically, somebody comes along with an idea for a patent, and you ask a number of questions. Does your invention obey the basic laws of physics? Yes or no? If no, well, you're not going to get a patent for it. If it's yes, they might say, well, the thing's worth billions, because some people have a very overblown idea of what value is. The thing might actually obey the law of physics in the inventor's mind, but be totally ridiculous. I remember a time when I heard about a guy who had a chair that could revolve at high speed, and the idea was that you strap a very pregnant lady into it, and in its revolving at high speed, you'll allow her to give birth more easily because of centrifugal force. Yes, so obeys the law of physics, but it's totally ridiculous and never going to make it to market, and you get that sort of what we call nutters in the landscape who have ideas for things that are never going to work. Working through the flowcharts, you may get to a point where, after answering lots of questions, you can say to your inventor, congratulations, it looks like you might be able to get a patent, though there are no guarantees. I'm not going to take you through this in detail, but basically you kick off with what we call a priority date. You've got 12 months before you can file a European application. There's what we call the Patent Cooperation Treaty. It allows you to get into the process of publication and toward granting of your patent, and then your national phases downstream. So, for example, the PCT phase has quite a lengthy process to go through, where examiners and intellectual property office people look at the idea, and it's put out there, and there's an international publication at 18 months before the preliminary examination at 28 months, and this national phases, which is your translations and so on. Copyright in the UK is automatic. So when you write something down or draw something, you're automatically allowed to assert your right over it. And the way we do that generally is to just write a line somewhere in the intro or at the end, usually on one of the cover sheets. You say copyright 2015, Anglia Ruskin University, all rights reserved. Boom, you've got your copyright. You've asserted your right over it. But you might also have seen the C in the little circle there. You can also use that. That's commonplace. Both of those things are fine. There is no Anglia Ruskin standard way of doing this as such, but they're happy if you do that. Sometimes you'll see documents here that don't have copyright asserted on them at all, oddly. But I think it's a good idea, personally, if you're doing something that you may publish or may want to utilise outside. Normally, it subsists over the life of the author. So if you're writing a novel, plus anything from 50 to 100 years, I think it's 70 years in the UK for duration of copyright after the life of the author. publisher's copyright, the sort that we'd have here, is separate from this regular sort of independent copyright and subsists for 25 years following the initial publication of a document. And software is normally protected through copyright. Less important here, but something, again, one of the intellectual property rights that we should know about is Crown copyright. It's the sort of thing where Her Majesty's Stationery Office produce something and they have a different type of copyright called Crown copyright, and for example the Department of Health or the NHS, they will utilise this means of copyrighting something, and it's 50 years after publication or 125 years after creation, which obviously can be two different things. One of the things that we come across more and more now is the Creative Commons. Some people consider that copyright itself is too restrictive. Creative Commons is an alternative to all rights reserved. So you can put on, in addition to the things that we said earlier, like regular copyright, you can put CC instead, and then one of these things in brackets. So you can say, all I want to do is attribute this to the original author, or I want to attribute to the original author and allow derivative works, or you can say I'll attribute to the author, allow derivative works as long as they're not commercial. So you have CC, BY, SANC, or you can have no derivatives, which means only the original work can be utilised in a form. So you put it out there in its entirety, in its original form. So I can say CC, BY, NCND 2012 Nigel Sansom is quite restrictive, but any of those is good as long as you assert which one it is. So Wikipedia uses a Creative Commons form. The sui generis is automatically subsists if there's been a substantial investment in obtaining, verifying, or presenting the contents of a database. So it's called database rights alternatively, and that subsists for 15 years after creation. They're not separate from copyright in the US, so it's different here than it is in other countries. But you'll also come across sui generis IP law in indigenous intellectual property, when indigenous tribes in the north of Canada, for example, qualify. Industrial design rights can be a form of sui generis in a class of their own, or plant breeders' rights, things that we're not really going to come across here in our day-to-day work. Trademark. So a registered trademark, you've probably all seen TM. We often say that TM means totally meaningless, but it stands for trademark, but it's not registered trademark, it's an unregistered trademark, and it's things for which you can't get a trademark. So you'll notice that Orange, the phone company, they have a TM because you can't trademark the word orange. However, if you were to start up a phone company and call it Orange because you think that the trademark is totally meaningless, you'll very soon find the weight of the law, because there's a law called passing off where Orange will, and their lawyers will argue that you're trying to look like them, which would be true. Apple similarly. But registered trademarks are very common also. You'll see the R in a little circle, much like the one that we use for copyright with the C. And oddly enough, it's not just things that can be printed, it's things that have particular shape. So, for example, the Coca-Cola bottle has changed over years, and that is itself a trademark. Design rights. Registered design rights give exclusive right in a design in the UK for up to 25 years, applying to two-dimensional as well as shape and configuration. Design right gives automatic protection for internal or external shape or configuration or of an original design, and lasts either 10 years after the first marketing of articles using the design or 15 years after creation of the design, whichever's the earlier. So they're the basic forms of IPR that we have to cover today. Sometimes it does get messy, particularly with patents. So when something of great value is invented, you probably all come across Apple versus Samsung in some form or other. They're always at each other's throats here. When numerous parties are involved, so if you're doing something where there's a patented thing here and there are numerous parties involved, it all needs to be really tightly controlled. And bad things do happen sometimes. And in the world of tech innovation, lawsuits often cost really dearly to the parties involved. Here's an example. This is a US example. That is Jennifer Doudna on the right and Emmanuel Charpentier on the left. They are two molecular genetics people that are getting a prize there from Cameron Diaz on the right. I'm not sure who the guy is on the left at some big show in LA. They were at this award. They got $3 million prize in California for this amazing thing called CRISPR-Cas9. It's a gene editing technology, and it's been used to cure muscular dystrophy in mice, to cure a rare liver disease in mice, made human cells immune to HIV, and enabled development of genetically modified monkeys. And there was obviously quite a lot of worries about ethics and where this is leading us with respect to designer babies and all sorts of other stuff. But it's out there, and no drugs exist currently from CRISPR, this gene editing technology, yet. And commercial control is likely to be worth absolutely billions. Jennifer Doudna formed a company with a guy called Feng Zhang, who was at the Broad Institute at Harvard, with a guy called George Church, who's very famous in the genetics world. And they formed a little company, spin out in the East Coast. And then Zhang put this patent in, asserting ownership and inventorship of the CRISPR technology. And it was unbeknownst to Doudna and Charpentier. Charpentier had a company as well. Doudna had a different company, and they all wanted to do this stuff, and it all got really messy. The patent gave Zhang complete commercial control of the technology. It was immediately licensed to Editas Medicine, which is effectively a spin-out from the Broad Institute, co-founded by Zhang and Church. Came as a complete surprise to everybody. Zhang and Doudna published separately in January 2013. Zhang claimed Doudna's assertion on use in humans was mere conjecture, and Doudna and Charpentier also filed shortly after Zhang. And this is currently in the law courts. It's a winner-takes-all interference proceeding where effectively the rights are transferred to the other party if they're successful. So you can see, there's a situation involving a patent of some university technology that looked really promising, everybody was excited about, and then there was this realization that it actually had some value, and then the realization it had a lot of value, and it got really messy. So how can we avoid such a mess? Well, keeping good and thorough notes. So good laboratory practice is really important for showing inventorship. So if you're working in a laboratory and you're doing stuff, people in pharmaceutical companies do this all the time. They know about, making sure that everything's dated and described in detail, and it's signed and effectively countersigned, preferably in lab notebooks that are archived, and go into some kind of repository downstream. You keep a really good check on everything you've done and who was involved and where. To know if there are any competing ownership claims. Ensure collaborators are on side, so that means getting the right agreements in place at the right time and that they're properly checked by legal. Know any promises to previous licenses. There may be some background IP, stuff that's been done before that enables a collaborator to actually suddenly say, actually, your foreground IP actually is mine. Sorry about that. Know if there are any rights you need to have to be able to do what you're planning to do. That comes back to the same thing about negotiating. Know who you're working with and know exactly what you're doing. Ensure you've fulfilled obligations to sponsors. There may be various people that are stakeholders in the whole thing, and you must ensure that you know exactly what you're supposed to do for them, when, and that you've done it, and all obligations are fulfilled. And keeping the senior management team up to speed is important, because we can help with the whole process. If you think you've invented something, what do? Do not disclose it. That's important. If you go and talk about it, publish it, create a poster for a conference, you've got a problem. because that means you can't go and patent the thing. So if you've got something you think is valuable, don't go ahead and just disclose it. Talk to me, Deputy Dean here is James Hampton Till, or the business manager, Amy, and we will help evaluate through IP due diligence and, where appropriate, begin execution to establish the appropriate intellectual property rights are protected. We may seek in-house support. We have a number of people in the university that can advise us. So, for example, we have a dedicated IP lawyer in the Vice-Chancellor's group who knows a lot more about IP than I do. And after we've protected patentable IP, disclosure can be made, but carefully. So if you're negotiating with a company, or we are, we'll ensure that we have non-disclosure agreements in place with companies so that they don't go and talk about it down the pub or to their mates. Discussions with potential commercial suitors need to be conducted under an NDA, this non-disclosure agreement, and with the full participation of the faculty senior team. So that concludes the brief intro to IP.